All right, wonderful. So this is our third and last case scheduled for argument this morning, which is case number 2010177, Kimberly Altman et al. Versus Dave W. Parker. If attorneys can please identify themselves and their readiness to proceed.
My name is Robert Kelly. I am appearing on behalf of the appellant, and I am ready to proceed, Your Honor.
Good morning.
Good morning.
Good morning, Your Honor. My name is Dan Wenstrup of Heiss in Wenstrup. I'm appearing on behalf of the Altmans, and I'm ready to proceed.
Thank you. Attorney Kelly, would you like to reserve time?
Yes, 4 minutes, Your Honor.
All right, and you can start whenever you're ready.
Your Honors, this is the initial appeal involving these parties after a remand from this court to hold a hearing that will allow it to allow the trial court to appropriately assess Mr. Parker's credibility concerning his claim that he was never served with this complaint. And I believe that the evidence was overwhelming that Mr. Parker was never served with a copy of the original complaint that was filed back in 1999, according to the Ohio Rules of Civil Procedure. Specifically, what I'm referring to is Civil Rule 4.1. This accident occurred on May the 2nd, 1997, which underlies the complaint. And the complaint was not filed until May the 2nd, 1999. During that 2-year period, the testimony of the attorney who filed the complaint evidenced that he did not do anything more than look at the complaint, the accident report, to determine Mr. Parker's address for purpose of service of the complaint. And I believe that the Sizemore case by the Supreme Court requires the exercise of reasonable diligence. In other words, if you file a complaint, you should do a little more than just look at the accident report. And in this case...
But that would be if it's required for it to go to the actual residence. Isn't the rule that governs where it's to go to is either the address of the defendant or an address where there is a reasonable expectation that it will be delivered to the defendant?
Yes, Your Honor. But in this case, where the complaint was sent was an address where Mr. Parker had not lived since 1986, and which was demonstrated in the record by his testimony. It was demonstrated in the record by exhibits showing that he did not live there, that he actually lived in Dayton, Kentucky, and therefore it was not a place where he could be served with a copy of the complaint. Even though the initial certified mail service was returned unclaimed, it was like the attorney just ran through the numbers. Well, if it comes back unclaimed, I'm just going to send regular mail service out. The problem is where the regular mail service and the original certified mail service was sent was a location where Mr. Parker did not reside and had never resided for approximately 13 years. On top of that,
what was the evidence in the record with regard to Mr. Parker's relationship between him and his grandparents? Because this was the grandparents' home, if I recall correctly, right?
It was a grandmother's home, and he testified that he lived...
So let me finish my question. So what was the evidence of the relationship, but the relationship as of late, as of within the few years of proximity to the time of service?
There was no evidence that he had any relationship with his grandmother, that he frequented that house, or that he stayed at that house. The evidence in the record demonstrated that he was living in Dayton, Kentucky. He had a lease for property over in Dayton, Kentucky. That was admitted as an exhibit. And
Mr. Kelly, to follow
Yes.
up on Judge Zayas's question, the record showed that Mr. Parker's father was at the default hearing, correct?
that's what was alleged, Your Honor. But if you read through the entire deposition, he was not there. The second thing is that Mr. Parker's father was there to attend the hearing. So we would have an issue with the deposition being admitted because there was no way that the grandfather or his father was not available. But even so, if the father's there at the hearing, it really makes no difference because the questions that were presented to Miss Altman was that he was down there representing Mr. Parker. And anybody knows that no judge, no magistrate's going to permit a layperson to come up and say they were representing someone else.
I understand that part. Isn't the fact that his father came to that hearing, isn't that indicative that the complaint and the service was reasonably calculated to provide notice to David Parker?
It's not indicative, Your Honor, because there's no evidence in the record, either at the default hearing when Magistrate Burnett heard this case, that Mr. Parker's father was even in the courtroom at the time of that default hearing. There's no appearance on behalf of Mr. Parker at any time. None.
Do you dispute that he was actually there in the courthouse?
Absolutely, I do, Your Honor. Absolutely, I do. Because if you read through the deposition, there is an absolute dispute whether the father was ever at that hearing. And if the question is whether he was ever at the hearing, the plaintiff should have subpoenaed him down because it's not as if he's not available. He is available to be a witness. Our job in that hearing was to demonstrate that Mr. Parker did not get service, and I believe that we did that. Through multiple exhibits, not exhibits generated by Mr. Parker, not exhibits generated by me, but through third parties such as Elise, such as tax statements, such as court records from the state of Kentucky that evidence that he lived in Dayton, Kentucky, Your Honor. So essentially what I'm saying is that there was absolutely no service on Mr. Parker as contemplated by the rules. And even if the certified mail service comes back unclaimed, you can always rebut the presumption that even if regular mail service was sent out, that it was not delivered to Mr. Parker, which in this case, we categorically demonstrated because the regular mail service was sent out after he was incarcerated in the Campbell County Jail. And in addition, it showed that his address at that time was in Dayton, Kentucky, on records from the state of Kentucky or the governmental units in the state of Kentucky. And those records were all authenticated and presented to the trial court. And essentially,
Kelly,
yes.
Mr. Kelly, the citation from the DUI in Kentucky,
Yes.
Correct me if I'm wrong, I'm trying to remember back. Didn't the police officer originally write down the Lowry Avenue address and then cross it out and put the Dayton address?
They did, Your Honor. They did. But he did put the Dayton address on the property. And that address is an issue that when Mr. Parker was issued his driver's license back in 1986, it was issued by the state of Ohio. The state of Ohio does not remove you from the driving records or BMV records until such point as you obtain a license in another state. Mr. Parker never received a license from another state up through and including the time that it was initially issued by the state of Ohio back in 1986, through and including after the period of his incarceration in the state of Kentucky. So it would always appear in the record as if they ran his record through the state of Ohio, that address would always come up. But that address is not the start and stop of an attorney's search for where an individual actually lives, such as the Board of Elections, property searches, etc. Or, to be quite honest with you, even going out and canvassing the neighborhood to determine if this individual lives at that address. None of that was done in this case. The attorney just took the address right off the accident report form and presumed that 2 years later he would still be living there because, as the attorney said, I've lived at my house for 15, 17 years. I mean, if anybody doesn't believe certain individuals move sporadically, I mean, I don't know how you disprove that. But I think that no matter what we would have brought down to the trial court, we would have ended up at the same result, because I don't know what other documents we could have presented to the trial court other than governmental documents which show that we have no involvement in it, to show categorically that Mr. Parker never resided at that Lowry Avenue address. And what's left hanging here is, when you read through the appellee's brief, he references that Mr. Parker lived at this address. He lived at that address back in 1986 before he got married. He didn't live at that address at any time during the 90s at all, at any time.
Thank you for your argument. Attorney Wenstrup?
Yes, Your Honor, and I will proceed. I appreciate the opportunity to discuss this matter of service with the Court of Appeals. In briefly referring to some of the matters that counsel has suggested, in his brief, he referred to Rule 4.4, which requires a defendant or an attorney to do a certain amount of searching before filing before taking the next step. But 4.4 deals with publication. We're not publishing in this particular case. And by the way, I wasn't a part of it. Greg Bellman was. But this is a different rule. When it went out certified mail and then it came back, the rule 4.6D just says you go out and you send the ordinary mail. The clerk fills out a certificate, and that's good service unless it comes back. It never came back. So what we have here is...
But Attorney Wenstrup, that goes straight to my question, because isn't there a certain responsibility? It's not like a plaintiff can put any address on the complaint and then direct the clerk of courts to serve on that address. You certainly are not arguing that.
I don't think there's anything in the rules which specifically refers to what you're talking about, but I would certainly suggest that every attorney has...
Civil Rule 10 discusses the complaint and discusses that it's, to be to the address. And case law has interpreted that to be the address of the defendant, or where there is a reasonable expectation that it will be delivered to the defendant.
And I totally agree with what the court has just referred to, that being that the service be in a manner reasonably calculated to apprise interested parties of the action and an opportunity to respond.
That's correct. And case law has determined that the address and an address where there's a reasonable expectation that it will be delivered meets that procedural requirement. So what's the evidence in the record that supports that grandmother's house is an address where it would be reasonable to expect that the service would be delivered to the defendant?
Your Honor, on 2 times in his deposition, he admitted that he had lived in that house. Not necessarily that he lived in the house at the time of the accident, but he said he had lived there. He never did a change of address, which is something you would do if you really wanted to live somewhere else. The police officer, Sergeant Lewis, also indicated that he should have changed his information on the BMV. He did not. He kept the Lowry address open so that he could basically screen what he wanted to see and not screen what he didn't want to see. He had testimony indicating that that his wife, first of all, he said his wife didn't give him any mail. And then at a later point, he said, a different time, after seeing he didn't get any mail, he says, well, she just gave me love letters. So I can see why the court would totally disregard what that particular witness would say. I think it's really telling that when the motion for default was heard and Kim Altman goes up in order to testify, lo and behold, there's his grandmother and there's a father. And they're there and they know about this case. They talk about the damage to the car. Where did they get this information? Of course, we all know where they got the information. They got the information from Mr. Altman. Maybe he was in jail at the time. I don't know. But just because you're in jail doesn't mean that you abdicate your residence. You can still have a residence over in Lowry or wherever he has it. And being in jail isn't necessarily going to stop that particular reference. But you know, when the father comes up and he says, I stand here for my son, David. I'm in his shoes. And I think he said something else in that way as well, but he knew exactly what he was doing. He was trying to help his son, and he was trying to help his son because we all know that his son needed him to do this, and that's why he did it. I don't know what else to tell you, but that being there for his son, I think was extremely important and showed that he did get service on this. Maybe they read it to him over the phone. Maybe they gave it to him with all the mail that he said he didn't get, but he really did get.
If they had read it to him over the phone, is that sufficient?
I would think that it is, because if nothing, it might tell him that he has to do more, that he has to go in and get service. Even with certified mail, if you don't claim certified mail and it goes back to the courthouse, you might eventually have to go to the courthouse and get a copy of it. And he might too. Maybe he couldn't immediately, but if he knew about the complaint, it was his duty to go there. Let me just, he needed an opportunity to respond. I think that's what the that's what the test says. And if I'm not saying that he did get it through the mail or on the telephone, but if he did, that gives him an opportunity to respond. You can't be dumb like a fox too much and say, I never touched it. And somehow it fell on the floor or whatever it was. He knew about this. And that's good service. I guess I would say that in my experience, I've done thousands of these myself, and I've seen other people do thousands of these type of things. If you get unclaimed, you then send it out. Now, if you don't have a clue, I think the court is correct that you can't just send it out to the byways anywhere. But he didn't send it out to the byways. He sent it out to where he had been and where he was getting information and where he had people who would go to court and say, I'm here in his shoes. He's close to these people. As a matter of fact, he moved back. So he's almost across the street from his grandmother. So this is the type of the family that would tell everybody or tell him what is important. And this lawsuit was certainly important. I don't have any doubt whatsoever that he found out about this particular lawsuit by his grandmother or his father.
Unless there's any questions from the panel. Okay, thank you for your argument this morning. Attorney Kelly?
Your Honor, first of all, the civil rules make it clear that the ultimate responsibility for effecting service of process rests with the attorney of record or the serving party. So Mr. Bellman had the obligation to effectuate service. This is not good service. When Mr. Wenstrup says, well, he lived there before, we're not disputing he lived there in 86. What the record shows, and that's what we're talking about, is what the record shows is that he moved out in 86. The record shows that he didn't move back there until sometime after 2011, 2012. No one can point to the statute or section of any code that says anyone's supposed to put in a change of address for anything. Matter of fact, if you go look at the reviver, at some point in time, Mr. Wenstrup found Mr. Parker over in Kentucky. That's where they served him with the motion for reviver. As far as references, that's the type of family this is. I don't know where that is in the record, and I don't know what specifically Mr. Wenstrup's referring to in terms of what type of family Mr. Parker has. As far as he could have been read this over the phone, he could have got this document from his family. That's simply conjecture. There's no reference to it in the record. As far as his father's testimony, there is no transcript, there's no document, there's no nothing with the father ever testifying in court or out of court that he was ever at the courthouse at any time for Mr. Parker. And the plaintiff cannot point to one point in the transcript where the father testified to that. And so any other testimony would clearly be hearsay because the father is not a party to the action. And then to say,
Kelly?
Mr. Parker.
Mr. Kelly, when did Mr. Parker's wages begin to be garnished?
That was sometime after 2012. 2012.
Okay. So why did he wait until, what was it, 2017 to move to set aside the judgment?
To be honest, Your Honor, he had poor legal advice who instructed him to file 2 separate bankruptcy pleadings in Kentucky, and he never had an attorney go through the records and really take a look at what actually happened in the case and review the documents for him. I did that. But the bottom line of the situation is whether he waited 20 years, 30 years, or 40 years, that void judgment is a nullity from day one up till now and can be vacated at any point in time. So in terms of him getting poor legal advice at that time, he's probably not the first person who's ever gotten poor legal advice from an attorney. But in order to address it, look at it, and find out what's going on, that's just essentially what you're supposed to do as a lawyer. And I got him through happenstance, not through any type of purpose. And I would also say this, Your Honor, there's no evidence the grandmother was ever down there. They could have subpoenaed her down to court. They could have subpoenaed the father down to court. But if you read through the judge's decision, and if you just read through it, it's like, you know, you talk about turning the civil rules on their head. In this case, the judge states, I believe it is Mr. Parker's obligation to provide a forwarding address. Okay? There's no law that says that. If you're in domestic relations court and you're already subject to the jurisdiction of the court, you have to update your address. But in this case, they never had Mr. Parker properly before this court at any point in time. And the fact that the trial judge wants to ignore a lease, government documents from Kentucky that show that there's no way that Mr. Parker could ever receive the regular mail service of the complaint, or that somehow or another it's Mr. Parker's responsibility to go in and get service at the clerk of courts for a case that he's not even aware of. You would have every individual in this county going down there asking the clerk of courts, was I sued today? If I was sued, can I get a copy of the complaint? That's what the civil rules are for. And the bottom line of this is, there in this record, the attorney who filed this complaint did nothing, did absolutely nothing other than pick up the accident report on the last day of the statute of limitations, threw the complaint in the hopper with the clerk of courts, and essentially said, I've done my due diligence. And there is no way under the civil rules, under applicable case law, that any diligent attorney would think, well, that's good enough. You might file the complaint to stop the running of the statute of limitations, but you're going to do some follow-up work to make sure that you have that individual sued and when in service on them. And especially in this case, Your Honor, because if you look at it, when was Mr. Parker garnished? It was approximately 12, 13 years later. When did the plaintiff attempt to garnish him? 12 to 13 years later. When did the plaintiffs ever attempt to find out what his actual address is? When they filed the motion for reviver, which was approved by the judge at that time before it was even sent out to Mr. Parker. And the bottom line of the situation is, this isn't publication. We're not arguing about publication. What we're arguing about is, did Mr. Parker receive this complaint at a place where he would normally be? And if the record reflects that he hasn't lived there within 13, 14 years prior to the filing of the complaint, and he has leases and documents showing that he lives in Dayton, Kentucky, you probably served him at the wrong address, It'd be like serving me at one of my children's homes. Do I go over there? Yes, I go over there. But when? not as frequently as I would like to, but the bottom line of the situation is they have no way to prove that Mr. Parker received this complaint other than pure conjecture that, well, you know, his grandmother or his father lived down there or something like that. It's all fine and good. It's all fine and good. They can live wherever they want. But your obligation as an attorney is to get it into the hands of the defendant, either by certified mail, personal service, or by residential service, if you know the person's living there. In this case, that attorney didn't know whether Mr. Parker was living on Lowry Avenue over in Dayton, Kentucky, or in Timbuktu, because they didn't do any of the legwork or what would be called due diligence to effectuate the service. It'd be like representing someone in a criminal case and saying, well, you really don't need discovery. We really don't need to know what's going on. We can look at the complaint and get a good idea. No, you're supposed to file the discovery, and you're supposed to turn over every rock in the stream for your client. That's essentially what you're supposed to do. And when you cut those corners, you end up with a situation like what we have today, period.
Thank you both for your arguments this morning. We will.
Thank you, Your Honor.
Thank you. Thank you both.
Thank you, Your Honor.
Thank you. And we will take the matter under submission, issue a timely decision. Wishing you both a wonderful afternoon and a wonderful Thanksgiving.